Hi, this is Alcam. Welcome back to my channel. Well, we have an interesting development from the Gateway Pundit. Matthew Graves, who used to be the U.S. District Attorney for Washington, D.C., who resigned last month, is now subject to a possible investigation by the U.S. Acting Attorney into the use of 1512C2 obstruction charges to lock up January 6ers. Apparently, he abused his power there, and he's now subject to an investigation by Christina La. So, acting U.S. Attorney for D.C., Ed Martin, initiate an inquiry into former U.S. Attorney Matthew Graves' prosecutions of more than 1,500 January 6 protesters. Ed Martin is specifically probing Graves' abuse of 1512C2 obstruction charge. Matthew Graves resigned last month, as already said. As for Jane Kelly, Ed Martin called for the use of 1512 to a great failure of the office and direct staff to immediately deliver all files, documents, notes, emails, and other information related to 1512C2 charging decisions to other two prosecutors who will prepare a preliminary report for Martin by this Friday. That's a tall order there. Oh, ABC News also confirmed A. Martin has initiated an inquiry to Biden DOJ abuse of the obstruction statute that was eventually overturned by the U.S. Supreme Court. So Biden corruption DOJ charged more than 300 J6ers with 18 USC 1512C2. Additionally, two of the four charges against Trump and Jack Smith's obstruction case also conspired to instruct, meaning also use 1512C. Then U.S. Attorney for D.C., Matthew Graves, arrested and charged thousands of nonviolent J6ers who didn't even enter the Capitol building. Repeat, didn't enter the Capitol building. Didn't do any violence. And he also threatened to seek more prison time for J6 defendants if the Supreme Court reversed the obstruction count. Oh boy. That's the first I heard of that. That's not good. Indeed, at any resentencing, the court could apply any upward departure for significant disruption of a government function, Matthew Graves said last March. In June, the U.S. Supreme Court delivered a devastating blow to Biden's corrupt Justice Department and overturned the obstruction charge used to jail hundreds of J6 defendants. The Supreme Court last year heard oral arguments in Fisher versus United States, and that issue was Statute 18 U.S.C. 1512C2, which reads, whoever correctly alter, destroy some kind of damage or conceal a record, document, or other obstruction, or attempt to do so with the intent to impair the object's integrity or available for use of a official proceeding, or 2, otherwise obstruct, influence, or impede any official proceeding or attempt to do so, shall be fined under this title or imprisoned not more than 20 years or both. A lot of people were not fined. In a 6-3 vote, the Supreme Court held that to prove a violation of the law, the government must show that the defendant impeded the available or the integrity of use of a official proceeding of records, documents, objects, or other things used in an official proceeding or attempt to do so. To prove a violation of Section 1512C2, the government must establish that the defendant impaired the availability or integrity of use in an official proceeding of records, documents, objects, or as we said, explained it late, whatever, earlier explained, and other things used in the proceeding or the intent to do so. See Supra at 9. The judgment of D.C. Circuit is therefore vacated, and the case is remanded to the further proceeding consistent with the opinion. On the remain, the D.C. Circuit may assess the sufficient court or count 3 of Fisher's indictment in light of our interpretation of Section 1512C2. The opinion read, Matthew Graves continued to threaten J6s with additional felony charges after the Supreme Court overturned the obstruction charge. Now we know why everybody was released. Matthew Graves. Let me read you what Judy Kelly said. She says the new U.S. District Attorney Ed Martin has opened an inquiry into the DOJ unlawful use of 1512C2, the post-Enron obstruction statute filed against 300 plus J6ers. Martin called the use of 1512C2 a great failure of the office and directs staff to immediately deliver all files, documents, notes, emails, and other information related to 1512C2 charging decisions to 2 other prosecutors who will prepare a preliminary report for Martin by this Friday. So what happened is, long before J6, you had the Enron Corporation that was involved in some financial shenanigans, and when they were being served with papers, they were shredding documents, trying to avoid presenting these papers to Congress. That's where this 1512C2 came to being. The problem is, we didn't see anybody on January 6th walking around with shredders, did we? No. Yeah, but the problem is that some of these people were charged, shouldn't have been charged. Some people were nonviolent. Some people were misled into going into the Capitol. And yes, with some people who did some dirty deeds that they shouldn't have done. And so far, out of the 1,500, only two people got themselves in trouble since. It's only 2 out of 1,500 people. So that's okay. That the second one, he's no longer on this earth. Don't ask how, but police took care of him. But Enron destroyed paperwork to avoid prosecution. There was a great fraud and manipulated the stock market and so on. So that's why 1512C was inactive. But the problem was these people were not coming in to destroy paperwork. They were upset. They were protesting the election. And we're still trying to figure out what really happened because, you know, we keep seeing more footage of that day. I didn't know about the bullets were being fired on the protesters that day. Yeah, there's a video of that. So the crowd might have been wild up by that. So that's we got a long way to go. And unfortunately, Mr. Graves, while he's doing all this nonsense with the January 6ers, he was also neglecting Washington, D.C.'s crime situation. Crime in Washington, D.C. has gone out of control. I mean, there was one case I remember where a little girl was shot in her bedroom. We don't know where the bullet came from. And you know, it was like you had Chicago on the eastern part of the United States. I mean, in that time, you had wild shootings all over the country in these blue cities. New York, Washington, D.C., Atlanta, Chicago, other places, St. Louis. It was out of control. It was the Wild Wild West, out of control there. Of course, California was same thing. So this was a bad situation, and unfortunately for Mr. Graves, this is going to be very grave for him because if they determine that he did these violations, guess what? He don't got a pardon. And neither does Jack Smith. They're totally screwed. And even those people who did get a pardon, well, they don't have the Fifth Amendment protections now. So if they testified and lie to Congress or in court, if they get a new charge, the pardon's not going to help them this time. So, Mr. Graves, I hope you are shaking in your boots as we speak, because the new DOJ is coming for you. And you might be doing some real hard time, maybe in the same prison you threw the January 6th people in jail. Isn't that lovely? Oh, yes. I can't wait to see you in handcuffs and shackles. So this is Al Kane saying so long for now, and don't forget, just stop.